So with that, members, let me call, this is the charge that says best interest of the child in family law. And the chair at this time calls Judge Judy Warney and Mr. Andrew Brown. Thank you all for being here. And Judge Warney, you can start first.
Good morning. Thank you, Mr. Chair, members of the committee. My name is Judy Warney. I'm a senior district judge from San Jacinto County in Texas. I served for a little over 13 years on an exclusively family court bench in Harris County. I was a family law trial lawyer for 21 years prior to that, and I also taught family law at the night class at South Texas College of Law for 15 years.
You can go ahead and proceed with your testimony, yes.
All right. I'm here to visit with you a little bit as a resource witness on best interest. And I think I've worked with a lot of you before, and I'm not here to talk about family violence except for just a little bit today. But best interest really came about in 1976, so a long time ago, in the case of Holly versus Adams, where the Texas Supreme Court outlined 9 factors that should be looked at by courts in determining best interest. And those 9 factors have sort of become the Bible for judges and lawyers on determining best interest as a way to look at all of the evidence that comes before you. The interesting thing about the 9 factors in Holly versus Adams is that was really a termination case. It was not a parental custody case. But be that as it may, those 9 factors have moved into the custody and possession arena and have become things that the judges look at when determining best interest. So in practice, best interest, from my perspective, both as a lawyer and from the bench, is really sort of like the old United States Supreme Court statement about pornography. I sort of know it when I see it, but I don't really know that I could plug all of the evidence that I receive into one of those 9 factors under Holly versus Adams. So what happened after Holly versus Adams? Well, the United States Supreme Court in 2000 issued the opinion in Troxell versus Granville. Troxell versus Granville was a non-parent versus a parent case. It was a tragic case where a father had died and his parents were seeking access to the child and sued the mother for access to the child. It was tragic on a number of different levels, but mostly because the parties fundamentally had an agreement that there should be an ongoing relationship, but they couldn't agree on what that relationship should look like. So, in other words, how often should the child see the grandparents and under what circumstances? That went all the way to the United States Supreme Court. The United States Supreme Court said there's a presumption that a fit parent looks out for the best interest of their child, and that unless you can show that that's not happening, then the decisions of the fit parent are what controls. And so they agreed with the mom that she could solely determine what the circumstances were that allowed grandparent access. They didn't discuss Holly versus Adams. They didn't really even outline all of the factors that should be looked at. It was not a Texas case that went up to the United States Supreme Court. Then in 2012, the Texas Supreme Court issued their opinion in In Re Stephanie Lee. And In Re Stephanie Lee sort of turned, from my perspective, best interest on its ear. Because In Re Stephanie Lee was a mediated settlement agreement where the parties had reached an agreement regarding the child, and one of the parents was having a relationship with a registered sex offender who had been allowed to be around and sleep with the child, the subject of the suit. The mediated settlement agreement allowed for ongoing contact, and it had some provisions that would be protective of the child, but the judge was concerned that the provisions weren't going to be enough. So the judge, on his own motion, said, you know what? Best interest controls everything under the family code. I'm going to have a best interest hearing, and I'm going to decide whether this is really good for this young girl. The judge decided it was not. The case went all the way to the Texas Supreme Court. Texas Supreme Court said no. The alternate dispute resolution statute says a mediated settlement agreement, if executed properly, is binding, and it's binding. And that means you, judge, don't get to look behind it and determine best interest. So we've got Holly versus Adams. We've got the United States Supreme Court saying parents have a right as long as they're acting in the best interest of the child. And then we have the Texas Supreme Court saying, well, that's not necessarily true if it's a mediated settlement agreement. Then we get to 2020, Texas Supreme Court comes out with the decision of in re CJC. CJC really has more to do with presumptions, but it also talks about best interest. So I want to back up a little bit and give you a couple of examples of best interest in reality that may or may not plug into the Hawley versus Adams definitions. So if there's some concern about whether we should legislate the Hawley versus Adams factors and define in the code that this is what best interest means, I want to give you just a couple of examples to think about. One is a young boy who was in foster care, and he asked for an in-chambers conference in my court. He was in a great placement, he was doing well in school, but the placement could no longer keep that child, either for age or because of complexities that come up in the foster parent's life. He was going to have to be moved. And so CPS had selected another very good home in a different school district. So this young man, big, burly guy, comes into my office and he says, I don't want to change placements. Well, I had to change placements because the placement couldn't keep him anymore. But what the question was is, what am I going to do in terms of where he goes? And I said, well, talk to me. You're doing great. Grades are great. You've been happy. He said, I've been in 6 schools in 9 years, and I made the football team. And he said, it's the only good thing I've ever done in my life. That's how he felt about it. And I want to play football. I don't care if I live in a closet. I don't care if I beg for food. I want to play football. So what does that have to do with best interest? Well, I don't know how you fit that in the Hawley versus Adams factors, except from my perspective, it was in the best interest of this kid to find a way that he gets to stay in the school district and play football, or he gets with a placement who can take care of the transportation and those logistical issues. So there's a lot of things that go in. Second story, 2 sisters. One has cancer and is dying, and everybody knows it. Young girls, middle school. The other is the sister. They're placed together. Same deal. Making straight A's, doing very well, everything's fine. She asked for an in-chambers conference, and she says, I want to change placements. And I said, what do you mean you've wanted to be with your sister all this time? And she said, I do want to be with my sister, but I want to change placements. And I said, well, what's going on? The placement had a medical background, was caring for all the needs of the sick child. And she said, my foster mom has a blog. And every morning she posts on the blog about what kind of night she had with my sister being ill. And she said, I don't want to start every day with all the kids at school and all my teachers reminding me that my sister has cancer. I want to be a 5th grader. And I want to worry about whether the kid that sits next to me in the cafeteria likes me. And she said, yeah, it bothers me that my sister's ill. It bothers me that she's going to die, and we all know that. But I don't want to start every day like this. And so what was in her best interest was bring foster mom in and say, here's the deal. We're going to move the kids, or you're going to drop the blog. Now, was that a sustained constitutional challenge for me to tell a parent they can't post? Probably not. But it was in the best interest. And once again, it just doesn't fit in those 9 factors. So I guess from my perspective, best interest is a little bit of I know when I see it. I have some concern that if you legislate these 9 factors, you're going to have judges who might say, you know what, I don't want to hear that evidence because it doesn't fit in one of these 9 factors, and this is what I have to consider. Or you might have judges who say, this is what I'm going to consider, and I don't want to think about all these other intangibles that might go on that impact whether or not the action that a judge takes is in the child's best interest. I'm going to be quiet now and let you visit, and then if you have questions about presumptions,
All right,
I can.
we'll ask questions after the
Okay.
testimony. Show Representative Wu present. Mr. Brown.
Good morning, Chairman Dutton, Vice Chair Lujan, members of the committee. My name is Andrew Brown. I'm Vice President of Policy with the Texas Public Policy Foundation. In addition to that role, I also oversee our work on child and family issues. In family law, as you know, there are a few principles more important than the best interest of the child standard. In our Texas Code itself, Section 153.002 says that the best interest of the child shall always be the primary consideration of the court in determining issues of conservatorship and possession of and access to the child. Despite the obvious importance of this standard, Texas Code offers very little guidance to courts on how to apply it. As Judge Warney said, it's a lot of, I know it when I see it. And some of this is understandable because each one of these cases is as unique as the individual family that's involved in that case. And there's always going to be that certain amount of subjectivity that's involved in judicial decision making when you're dealing with these complex family dynamics that vary from case to case. However, in many ways, Texas is an outlier among states in the fact that we have very little guidance in code on how to apply the best interest standard. For example, more than half of all states, not including Texas, have language in their codes emphasizing the importance of family integrity and preference for avoiding the removal of the child from his or her home. Approximately 22 states, as well as the District of Columbia, have statutes that list specific factors for courts to consider when making a best interest determination. We have something similar in the sense of the Hawley factors, but that's case law rather than statutory law. Interestingly, there are 3 states that I was able to find in the research that I did on this topic, Connecticut, Delaware, and Idaho, that actually list factors that courts may not consider when making a best interest determination. And this includes things like the birth parent's sex, their socioeconomic status, and even their disability status. As Judge Warney said, the relevant factors that kind of been the leading case is that 1976 case of Hawley v. Adams. One thing to note about Hawley is that the Supreme Court of Texas, in its opinion in that case, cautioned that these 9 factors are not exhaustive and may not apply in every single case that may come before a court. They have since taken on almost canonical status with courts, and you see courts being very disciplined with the Hawley factors or heeding the court's caution and saying, well, we can consider these, but there's this other universe of things that we feel like we can consider when making a best interest determination. Why this is important is because both the United States and Texas constitutions recognize that the relationship between a parent and child is a fundamental right that's deserving of expansive constitutional protections. The U.S. Supreme Court has jurisprudence going back now more than a century that the government may not interfere with the parent-child relationship absent a compelling state interest, even to the point where there's cases that say if the fit parent is making a decision, then the court may not substitute its own judgment for that parent's judgment even if it thinks a better decision could have been made. There are obviously exceptions to that for the safety and well-being of the child, but our constitutional jurisprudence holds that courts are required to presume that parents are fit and that it is in the best interest of the child to be raised by their natural parents, and that decisions that fit parents make for their children are presumptively in the child's best interest. And Judge Warney mentioned In re CJC, which was a most recent landmark decision that touched on this best interest question. And I think the Supreme Court of Texas made it abundantly clear when it held that when applying the best interest standard, a court must apply the presumption that a fit parent, not the court, determines the best interests of the child. And when you read CJC, essentially what they're saying, from my interpretation of it, is the fit parent presumption is inherently built up into a best interest determination. You can't separate those two determinations. And so any legislative action that you all take to provide clarity in the application of the best interest standard really should start from this fundamental principle. Last session, Representative Cook authored House Bill 3072 that attempted to do just this. It attempted to address that lack of guidance and provide a little bit more of a foundation from which courts can start from. And that's how I kind of think about addressing best interest, because of the infinite number of cases that will fall under the best interest standard. You really can't have this overarching definition that's going to apply in all cases, but you can set a floor. You can set a common starting point for courts to begin their assessment from. And then by doing that, I think you can bring more consistency and uniformity into the application of this standard in cases that are very different from each other. Over the interim, the Texas Public Policy Foundation has been working with a group of stakeholders that are concerned about this issue, and we're working towards agreement on statutory language that will finally provide some of this clarity that Texas has thus far lacked. Now, these conversations are still ongoing. They're moving in very productive directions. But at minimum, we at the foundation believe that any language should include, or any statutory, any bill passed by the legislature should include statutory language that emphasizes that when you have a suit involving a parent and a non-parent, there is this rebuttable presumption that the parent is fit and acts in the best interest of their child. Furthermore, that it is in the best interest of the child to be in the care, custody, and control of their natural parents. And furthermore, that this presumption should apply throughout the life cycle of that case unless that fit parent presumption has been previously overcome by the presentation of evidence and rendered in a final judgment regarding that child. A key aspect of the American tradition of the rule of law is that the laws be applied predictably and uniformly. Lacking statutory guidance for best interest undermines this concept. It creates unpredictability. It creates uncertainty. And by creating this foundational floor for the definition and the application of the best interest of the child, we can introduce that predictability and uniformity so that when families enter court for these most important cases that our system deals with, they will at least have an understanding of what is going on and what they can expect to happen based on the unique facts of their individual cases as well as the evidence that they'll be presenting. I appreciate your all's consideration of this very important issue, and I thank you for the opportunity to testify today.
All right, thank both of you. Let's see if there are any questions from the committee in terms of this question. Any questions, members? I'm struggling with, I guess, what you said, Mr. Brown, at the end, that if the legislature chooses to get into this and come up with a definition, is it going to help the situation? I mean, if we just legislated the Holly factors, for example, what would that do?
You want to answer?
I'll go first.
Okay.
I don't support legislating the Holly factors because that is a unique case that involved TPR, and it would go against what the Supreme Court even said about its own opinion, that these may be considered, they're not exhaustive, and they may not apply in every case. Based on our research and what we've seen in other states, that foundational definition, right? This is the most basic fundamental principle for the court to apply when they start, at least gets you closer to a more uniform application. You're always going to have unique facts of cases. You can't control for that, and I think for the legislature to try to do that would create more confusion. But making sure that all of our courts have a consistent understanding of what best interest means will take away a little bit of that. If I know it, then I see it, and specifically some of the subjectivity that comes in where it matters what court you end up in as to what the judge is going to say is in the best interest of your child, right? And that's where, especially in family law, we have a lot of challenge because in a lot of cases, it does matter which court you get into on how they're going to be applying the various standards. And I think that creates a lot of frustration for families, creates a lot of frustration for attorneys across the state who are trying to figure out, well, what does this mean in my case? Because courts are so divided and all over the place over this very issue.
And then you've got, every case is different.
Right.
Every case is different, every situation is different, and we as legislators are trying to prescribe the playing field for all of them.
Well, and best interest is listed in a lot of different places. You have best interest of the child for conservatorship. You have best
Yes.
interest of the child if you're not going to follow the standard possession order. You have best interest of the child in child support, in adoptions, in determinations in CPS cases. And I don't think that those definitions will look the same. And so I think if you want to tackle defining best interest, then you're going to have to tell the judge, okay, well, if this is a termination case, then this is what best interest is going to look like. But if this is a child support case, then this is what best interest is going to look like. And I don't really debate that it would be wonderful if we had more consistency among the courts, and certainly that was challenging in Harris County, where we had so many family court judges and associate judges who had different at times kingdoms, for lack of a better word. I'm not sure that you can legislate better decision-making by the judges. I think the judges who really want to do the right thing and do it well are going to read the case law and be familiar with the code, and they're going to do what really is best for that child, rather than saying, okay, well, let me open the code like they do with child support guidelines and say, well, this is what you get because everybody else in your situation gets the same thing, because the kids are just so different. And I do agree with him. Consistency would be better, but I'm not sure trying to define best interest of the child in 5 different places or 12 different places is really going to bring about the consistency that you hope it will accomplish.
Mm-hmm.
Okay, show Mr. Cook, the guy who started all this, present. So, best interest of the child itself is a standard that can change depending on the situation.
It can.
Then, should we try to create a standard for each one of those situations?
Well, I think part of the problem with trying to define best interest, and he's touched on this, and I totally agree with him. Every case is so different, and it might be in the best interest. I had a judge in Jefferson County one time find it was in the best interest of children to go to tennis lessons, because it was what they had been doing. They were embroiled in this horrific fight. It was one thing the judge could do that would be some consistency. And that's not, and I'm not suggesting that you would try to legislate every single circumstance, but that's an example of a time when a general definition of best interest isn't going to help the judge. You're going to need a judge who really cares, has listened to the evidence and thought, you know what, this kid really should keep going to Kincaid, or this kid shouldn't keep going to private school, or have tennis lessons, or carry a cell phone, or because there are so many issues that come before us. And as a practical matter, we've been doing this. I mean, I remember one of the first cases when I went on the bench in 2005 was over shin guards in soccer. And so the fundamental issue was, well, is it in the best interest of this kid to keep playing soccer? I mean, what are we doing with some of these issues? And I don't mean to minimize the significance by putting up a trivial example, but it really is true that every one of these kids has very unique needs, and that what may be in this child's best interest may actually not be in the next child's best interest.
Representative Wu?
Thank you, Chairman. And help me try to kind of fully understand this, sum up, and says this is the way I understand it. The existing law that's on the books has, over the past decades, through tens of thousands of cases in the appellate courts and whatever, have been hammered, have been mashed, and sort of like evolved into the system where everyone, it's not perfect, but everyone kind of knows what it is and what it means. And that if we try to pass something to define it exactly, it'll overturn all that, it'll overturn the apple cart. And it'll actually potentially make things worse for families, because now, if we encoded the Holly decision, right, and put it in the law, that actually would potentially could redefine what those words means, because then we are adding in legislative history into those terms, and then when people fight over exact definitions, and people say, well, it doesn't mean what the court meant back then, because now you've had this separate debate in the legislature over what this term means, and I think this new interpretation should hold over the old interpretation, right? And it could cause more problems.
I think you're right. It could cause more problems, and it could be challenging. And again, I don't know that the judges are going to be better because of it.
Right.
And we're courts of equity. Family courts in Texas are courts of equity. We're supposed to do what's fair and equitable. Right. And so hopefully legislation would be guiding and helpful in that, and not make it more challenging.
And I think there's I'm not sure if you see it the same way, but I think there's a big difference between the legislature telling the courts and juries what is best interest versus the legislature telling them, well, these things are not to be considered in best interest. Say, like, if one parent has more money than the other parent, we say you may not consider this, versus us over here telling us you must consider these factors, because that could mean that you don't consider other factors. But we are saying over here, as a public policy issue, we don't want you to discuss which parent can buy the bigger car for the kid. That's absolutely prohibited. Are those things same or different?
I think it's very different. Saying you can't consider, for instance, you can't consider the religion
Right.
of the parents, versus you must consider these 4 things, or
Right.
these 3 things, or these 7 things, some of which may or may not be relevant with
So-
regard to the particular child in front of you.
So that being said, if the legislature wanted to do something in this arena, maybe a discussion about maybe we should prohibit certain types of considerations, such as religious considerations, right, or money factors, or different things, or we have a prohibition that says you may not discuss that a mother is better than a father at parenting, right? If that's brought up, that's an immediate stop to the trial, and then you're going to have to address the jury and give an admonishment to the jury.
And some of the examples that you give, like the tender years doctrine, has been basically done away with by case law.
Right.
And so, and it doesn't require statute to say, oh, by the way.
Right, and potentially, if we pass new statute, that new statute could be seen as overriding existing case law that would govern it.
I think that's true, and part of my concern is it would also be seen as limiting you,
Yes, thank you.
which is a bigger concern.
One of the things it raises is the question of we develop a statute and it's really a one-size-fits-all. But the thing that raises a question in my mind is whether or not inner city Houston ought to be treated the same way as Canadian Texas. I mean, and whether regional considerations ought to play a role. Because what may be good in Canadian Texas may not be good in Fifth Ward, Texas. Or best interests of the child may be considered one way in one area versus another area. And I know we're getting into the weeds on this, but should the legislature even? I mean, it's not going to go away if we do nothing.
Correct.
The question is not going to go away if we do nothing, and it's going to get. I project it's probably going to get a little bit more, rather than getting better. It'll get less better, not worse, but less better. And I'm not sure what that means for us as policymakers, whether we ought to stand up and say, well, recognizing it's difficult, here's what we can do or say about it. And I'm not sure how to proceed in it, because I recognize that best interest of the child generally is considered, and I mean generally talked about in terms of access to the child. But it also applies, I think one of you mentioned, to child support, for example. Should you consider best interest of the child, and is it the same standard when you're looking at child support versus access to the child? I'm not sure whether the Holly factors even make a distinction, or whether or not there's something else that governs when you're talking about one situation versus the next situation.
Well, and that's,
what-
go ahead. No, go ahead.
I think what was so brilliant about what Representative Cook's bill was working on last session was it didn't get into all of the things that we've been discussing here today, all of the variations and how this might appear in a custody case versus a modification case. It really started from what are the foundational principles that we know and expect to apply? How should every family be treated when they walk into a courtroom? And that's the guidance that we recommend and that Representative Cook's bill was working on providing, right? Providing that set of standard principles that every family deserves will help in addressing some of these cases that have caused us to come into this room today. You know, CJC is a prime example. one of the reasons CJC happened was because the judge had a different opinion of what was in the best interest of the child than the child's fit, loving father, and found a way to get around what you all had already put in statute to get the outcome that judge thought was best. Now, fortunately, it made it to the Texas Supreme Court, and the Texas Supreme Court overturned that decision. It cost that father a lot of money. It cost that father a lot of time and a lot of heartache. And that's one example of, I think, why having that baseline starting point for best interests that is in the code that you can point to, rather than having to go to all of these different sources of case law that says this is where the judge has to start from when they're faced with the best interest determination, right? Because otherwise you can get into these decisions. We talked about, sports earlier, right? Fit parent, if they want their child to play one sport based on constitutional principles, the court can't come in and say, well, we don't think your child should play football because of the risks of head injuries and all of these different things. We think they should play soccer, right? If the parent is fit and they're making that decision and there's no danger of harm to the child, then the court should not be able to make that type of a decision. Now, that's a very simplistic example, but I think it illustrates the fundamental principle that we're talking about.
And so I assume there's some standard for making a determination as to whether the parent is fit.
Not really.
That's what I was worried about, that you say that, well, a fit parent can make the decision what's in the best interest of the child, but then that raises the question of what's a fit parent.
And I think that's a judicial determination. I mean, from my perspective, you would listen to evidence about what are the decisions the parent's been making? How have the parents been behaving? What have they done in and around the child since the child's birth to each other in a relationship? I mean, has that parent made poor decisions in the past that would make the judge determine that they're unfit? And on that topic, one of the other things that I struggle with, and I think we agree on some of the presumptions of that courts should stay out of the way of fit parents who are not doing anything that's harmful to their children, and their children are thriving and they're doing well. Last session, the legislature passed a bill that said if you've been terminated, you can come back and ask to have your kids back and basically be reinstated as a parent. And so these are parents, from my perspective as a judge, if I'm going to terminate someone's rights and I say to them, this means that I have determined that for the rest of your life, you can't parent this child. Because if I thought you could, I wouldn't terminate you. I would do some other arrangement in an order and see, how we go. Well, last session, the legislature said no, even if they've been terminated, as long as it's been an agency termination, if they want to come back within a 2-year period and say, I want to be parent again, that under certain circumstances, the courts have to allow them to make that request and then make a determination. And so we've already determined they're not fit. And we're still going to let them come in and say, okay, well, I've got my act together. Do parents get their acts together? Absolutely. But at some point, there's got to be some finality. And so I think that statute that went into effect last September has sort of turned the parental presumption issue on its head. We don't give them the presumption of being a parent, but we certainly let them come in the door and say, I'm a parent. Because at that point, they're strangers to the child. When you sever a parent-child relationship, you now have these parents who are like somebody that's never met this kid. But we're saying, because you used to be a parent, that in and of itself gives you standing to come in and say, okay, I'm ready to parent again. And I know I've really gotten off in the weeds on
That's
that
all
one.
right.
But in terms of just talking about consistency in the code and the way we're going to talk about parents and presumptions in best interest, that certainly is a, whoa, where did that come from issue.
Right. So we shouldn't muddy the water by, and I don't know if there's lots of case law about making a determination about what a fit parent is. Is there any case law or something? I don't believe there's any statute.
I don't think there is either, and I think that also is a scary thing to try to legislate. And you gave the perfect example. I grew up in Houston, lived in Houston my whole life until I retired. I retired to Cold Spring, Texas, population less than 900. If a child in Cold Spring, Texas is walking to school half a mile, I'm going to say, well, okay. If you are in certain areas of Harris County and the testimony before the court is, this kid's got to walk to school half a mile every day, there's a different part of the hair on the back of my neck that's standing up in that, and all of that sort of goes into best interest. But that doesn't mean the parent in Cold Spring is not fit. It means under the circumstances as they existed, they made a really good decision with regard to the kid. Same decision in Harris County might not be a really good decision with regard to the child.
I feel like what's being lost in this conversation, though, is the fact that the fitness of a parent is a presumption that's required by constitutional law. Is there case law? Yes, there's Supreme Court jurisprudence that says you must, as a court, as a matter of constitutional law, presume that the parent is fit. And then you may overcome that presumption with compelling evidence that shows that for whatever reason, decisions that the parent made that are so out of the ordinary or puts that child in such a dangerous position that, okay, this parent's not making the decisions that a fit parent would make. But we can't lose sight of the fact that we have to start with the presumption that every parent enjoys under the Constitution, that they are presumed to be fit unless it can be proven otherwise.
I totally agree with him, and I just don't think that defining best interest will impact that. I completely agree with him that that's the presumption, and it's in a number of places in the family code.
Mr. Cook.
Yes, sir, Mr. Chairman. So what is best interest?
It's, before you came in, I said, unfortunately, the way I look at it is I know it when I see it. You listen to all of the facts, you listen to the characteristics with regard to that child. What is that child going through? What are those circumstances? And you try, I think, at least I did and do, try to think about the fact that you're seeing these parents in many circumstances at the absolute worst they will ever be. People behave in family law conflicts in ways they would never dream of behaving and in ways that they would tell you they would never behave that way. And so you have to sort of pull all of that out of these horrendous circumstances and say, okay, what is going to best suit this child with these parents in this neighborhood at this time in this grade, and that will carry them through into the future.
So if we lined up 100 judges, we probably would get 100 different.
You probably would.
And so would you agree with me that one of the most important concepts in the Texas Family Code is best interest?
I do.
Okay. So would you also agree with me that I think Chapter 101, where it has a lot of definitions within the Texas Family Code, the legislature has saw fit to make definitions for a lot of different terms within the Texas Family Code, correct?
They have.
Okay. And we just talked about that one of the most important concepts is best interest of a child, correct? And so wouldn't it give more objectivity and less subjectivity of the judge if you had some type of definition of best interest?
I don't know that it would make the judges more consistent. And that's what I was saying earlier. I don't think that it would.
Do you think it would make it more likely or less likely that it would be an objective decision?
More likely that the judge would make an objective decision if there was a definition?
Mm-hmm.
I would say I don't think it's going to be more or less likely. I think judges are still going to do what their gut tells them is in the best interest of the child and try to fit it into whatever the definition is.
So if there's a law that defines best interest, do you think the courts would just ignore the definition?
I don't think we would ignore it, but I don't think that you can create a law that defines best interest that's going to cover all the circumstances.
Have you reviewed the bill that was filed last session?
I have.
Okay, and it's pretty obvious what the bill is, right? I mean, the chairman's talked about the Holly factors, correct? Is that simply what this bill did, is put into statute the Holly factors?
It along with some other things about presumptions, yes.
Well, I think you're probably talking about two different bills. House Bill 1197 just basically lists the Holly factors.
Okay.
It says, in determining the best interest of the child, in addition to any other factors the court is required to consider under this chapter or other law, the court shall consider the following factors. And so have you ever made a custody determination without using the Holly factors? The answer is no, most likely.
Pardon me?
You probably have never made, let me put it a different
Without
way.
considering them, I would say no, but could I say in every case that every single one of those factors applied? I would have to say no.
Okay, well, I can read it to you again, but it did say everyone has, because it gives you a list. I mean, you're familiar with the Holly factors. I mean, so as you go through those, I mean, some of them are not going to apply to each case. Is that correct?
I would think so.
Yeah, but don't you think it's in the child's best interest that you would review the Holly factors that it's already in case law, correct? I mean that's what Holly is. It's a case, a prior case, and so it's precedence, correct? And so I just want to know, in your opinion, why would it not be in the child's interest to have a definition of best interest?
Because I don't think it would change what's happening now. I don't think it would. I'm not a person who thinks that we should have legislation so that every judge out there who isn't already reading the Supreme Court of Texas case law and following it, so that the lawyers can point to this section and say, well, wait a minute, you didn't consider that there might be programs available to this parent to help with whatever this issue is.
So would it make the bill better if it said that, I mean, because it says you can, the best interest of the child shall always be the primary consideration. The court in determining the issues of conservatorship and possession of the child in determining the best interest in addition to any other factor. So it doesn't say you can't consider other factors,
Correct.
Okay, so it says you can consider any factor you want, but you shall consider the Holly factors, and you're already doing that, correct?
I would say yes, but I would also say that it don't all apply. I mean, if somebody said, give me a finding of fact on what plans are available in the example I gave with changing a placement of a child because of where he wants to go to school, I would have to say I can't make a finding about plans that are available or resources that are available or acts or omissions of the parent. I mean, the reality is none of that had anything to do with the 9 Holly factors. And if I shall consider all of those, I mean, I guess I could make a findings. I considered them and they don't apply.
Correct. That's. I mean, it doesn't say that they're all going to apply.
But if that's what we're doing, then, and I'm starting to sound like I'm being argumentative with you, and I don't mean that.
That's fine.
And it's clearly an issue that is challenging for lawyers, judges, and the legislature. But I'm on a different page than you about how many definitions and regulations we should include in the family code versus how much discretion we should let the courts have.
Because right now, that's what the court's discretion is simply the best
To determine
interest.
best interest, yes.
I mean, it's wide discretion, correct?
It is.
Mr. Brown, anything else that you would like to add to this conversation?
I think any action that the legislature takes should be simple. It should not go into, as was alluded to earlier, do we need to go into every single section of the code that deals with all of these different scenarios and create a best interest determination for each one of those? I don't think that's necessary. I think what's necessary and what will improve judicial decision-making is providing that very fundamental baseline definition that communicates the principles that apply to every single family who enters a courtroom in the state of Texas with issues involving their children, regardless of what that case is and regardless with what other factors will come out through the evidence. I think what you were started with House Bill 3072 last session really is moving us in that positive direction to make sure that we don't end up with the number of cases that we're getting at the state Supreme Court. I think these issues of family law are one of the top cases that the Supreme Court of Texas takes up, and it's partially because we don't have consistent guidance for courts, and you have this, I know it when I see it, happening in 254 counties across the state. And each one of those judges has a very different viewpoint of what's best for a child, and each one of those judges knows something different when they see something. So providing them with at least that lens that puts them on target and then allows them to use their discretion as the facts and the evidence of that case unfold, I think leads to better judicial decision-making, but does not require the legislature to get into micromanaging the very fine details of each one of these unique cases.
And going back to HB 1197, I was pulling it back up, but number 10 says any other factor the court considers relevant to the determination. So would you agree with me that number 10 that I just read still gives the court the same discretion that they have today?
Absolutely.
Okay. Thank you. Thank you, Mr. Chairman.
All right. Any further questions, members of this panel? Thank you all for helping us know what we don't know.
Thank you.
Thank you, sir.
Thank you all. Chair calls now, we're going back to interim charge number 1, and the chair calls Ms. Chandra Carter, Mr. Sean Grove, Mr. Daniel Guardo, and Robert McCleskey. And while you all are coming, let me apologize. I told Representative Thompson we were going to try to do this together with her committee, and I simply forgot it.